As part of our ongoing role in support of our judicial network in Central and Eastern Europe, the CEELI Institute presents Judiciaries in Peril. This series shines a spotlight on pressing issues facing the judiciary in key countries of the region and explores the challenges faced that undermine and imperil that nation's judiciary and the rule of law. Thank you for joining us for this fourth in our Spotlight series, where we focus on the judiciary in Romania. I'm FREDA GREALY. I'm a Programme Manager at the CEELI Institute based in Prague. I'd like to hand you over to Chris Lehman, Executive Director of the CEELI Institute, for a brief introduction.
This is one of our core parts of our mission at CEELI. We are committed to support for independent judiciaries across this region, as it is fundamental to the rule of law. We're delighted with the panel that we have here today. It's appropriate in celebration of International Women's Day that we have a panel of all women, but that was not put together for Women's Day. I think it's really just a reflection of the fact that women are front and foremost in all aspects of judging and politics and policy across the region. So what is a nice coincidence, I think really also is an important tribute to the meaning of International Women's Day. So I don't want to cut into our speakers' time. We are delighted with this program, and we look forward to continuing this series in the coming months as we look at other countries across the region. So FREDA, I will pass it back to you.
Thanks so much, Chris. So as Chris said, we've three excellent speakers. We're very pleased now to introduce them to you. Firstly, we have Judge Andrea Chiș. She's from the Cluj Appellate Court. Her career spans 20 years in the Romanian courts, and since 2017, she's elected for a 6-year term as a member of the Superior Council of Magistracy of Romania. With transparency as a personal goal, she has focused her energy on projects related to communication and independence of the judiciary. Among her achievements, she drafted, launched, and coordinated the Integrated Communication Project on the Romanian judicial system. She was an organizer, speaker, and expert in the 2019 to 2020 European Judicial Training Network projects and trainings on communication and the rule of law. She's participated in UNODC projects on communication and the use of social media within the judiciary. She's a promoter and supporter of various initiatives of NGOs and professional associations on the rule of law and judiciary independence. Then we will have Ramona Strugariu, who is a member of the European Parliament for the Freedom, Unity and Solidarity Party. Before she was elected, she was the Parliamentary Assistant and Chief of Staff of a Romanian MEP, where she contributed to the political activities of numerous committees and working groups in the European Parliament, including the Committee on Civil Liberties, Justice and Home Affairs, and the Working Party on the Rule of Law and the Fight Against Corruption. Ms. Strugariu is a graduate of the Faculty of Law at Alexandru Ioan Cuza University, where she also earned her master's degree in European law. Thirdly, we're delighted today to have Laura Ștefan on the panel. She's Executive Director of Expert Forum and Chairperson of the Regional Anti-Corruption Initiative, and she is a former director in the Romanian Ministry of Justice. She is a leading anti-corruption expert and an international expert on rule of law with the European Commission, the World Bank, UNDP, and the Council of Europe. Ms. Ștefan graduated from the Bucharest School of Law and the Master's Programme at Cambridge University. Between 2005 and 2007, she was director within the Ministry of Justice and was responsible for anti-corruption policies. She drafted and advocated for anti-corruption legislation, elaborate programs for civic awareness, and worked to reform the Public Prosecutor's Office. So that's our panel for you, ladies and gentlemen. Judge Chiș will go first, and she will address you in English, and Ramona will also address you in English, and Laura will present in Romanian. Each speaker will talk for about 10 to 15 minutes, and the discussion and Q&A will follow at the end. A reminder again to ask any questions you have in the questions and answer feature at the bottom of the screen, and any other comments you can make in the chat function. So I will hand over now to Judge Chiș. You have the floor.
Hi everyone, good afternoon. Thank you, CEELI Institute, for inviting me in this very special day, celebrating Women's Day, in this very special panel with two wonderful women, two great speakers speaking about this topic of utmost importance. Being a judge, I will try to present this topic from my viewpoint, as probably my women colleagues will do from their viewpoint as a politician or as a representative of the civil society. I will try to divide my presentation in three main parts. In the first part, I will try to review the period of time between 1989 and 2017, so a short history of the development of the Romanian judiciary, the progresses we registered till I became a member of the council. The second part will be about the last year starting from 2017, because in my opinion, this was a shifting point, and I will tell you why. And in the last part, I will try to present the present moment, and some future plans. So I've been a judge for more than 25 years. I was the first generation after the so-called revolution. So I went through this process from a communist regime to a democratical one. You know, I was there when we adopted a new constitution in 1991. Followed by a new law on the judiciary in 1992. Of course, there were most of the attributions related to the career of the judges and prosecutors and administrations of courts were still in the hand of the Minister of Justice that time. But according to this law, we established a judicial council. That is true. That council did not represent all of the judges because its members were appointed by the parliament in a united meeting based on the proposals made by the appellate courts and the high court and the prosecutorial offices attached to them. When we decided to become a member of the European Union and implement the acquis communautaire, we changed some provisions in our constitution in 2003. And according to them, we changed the laws on the judiciary. We had three laws in 2004. One on statute of judges and prosecutors, because in Romania, judges and prosecutors have a similar statute, not an identical one, just a similar one. Another law on judicial organization, and the third one on the judicial council. It was a long road, but we had a council, a very modern one, actually, one of the best, at least on the paper, comparing with other judicial councils, because we are 19 members, 9 judges elected by our peers, representing all the courts, basic courts, district courts, appellate courts. I'm one of the representatives of the appellate courts and the high court, 5 prosecutors, 3 ex officio members, the president of the high court, the general prosecutor and the minister of justice, and 2 representatives of the civil society appointed by the Romanian Senate. From 2004, the Judicial Council is in charge with the career of judges and prosecutors, with the appointment of the presidents of the courts. The Judicial Inspectorate was attached to the Judicial Council. The chief inspector and the deputy chief inspector were appointed by the Judicial Council. The Judicial Council adopted the regulation of the Judicial Inspectorate, comparing with the first law, when which provision said that the Judicial Inspectorate were functioning within the umbrella of the Ministry of Justice. The chief prosecutors were appointed based on the attributions divided between the Minister of Justice, the Judicial Council, the Division for the Prosecutors, and the President of the country. So two specialized prosecutorial offices were created. You know very well one of them. We speak about the National Anti-Corruption Directorate. So it was a long process. We became independent. We fought against corruption, and till 2017, I think we became an equal power with the other two branches of government. I think it was the first time in our history when we can speak about such a balance between the three branches of powers. What happened in 2017 and why all those things happened? I think this was because the National Anti-Corruption Department had many successes in its activity. We speak about corruption cases against members of other branches of powers and also judges and prosecutors. But somebody who works a lot could make mistakes also. So it was somehow, before speaking about mistakes, we are going to speak about results. So we had these results. We had final convictions related to the representatives of other branches of governments. We speak about a former prime minister, members of the parliament, so on and so forth. So somehow it was natural for the other branches of power to try to fight back, because in 2017 we had general elections, we had a new parliament, we had a new executive, and we had a new judicial council, because I was elected as a member of my council in 2017. And we started our mandate with a real challenge, because the executive tried to pass an emergency ordinance trying to change some provisions in the criminal code and criminal procedural code. Because of these high corruption cases, trying to actually decriminalize some provisions related to the fight against corruption. They did not succeed. Even though they tried it again somewhere in 2019, because the law was dismissed, was considered unconstitutional by our constitutional court on procedural grounds. Still, they tried to control somehow the judiciary. They didn't manage to decriminalize some corruption of some criminal offenses related to corruption cases. So they try to control somehow the judiciary. That is the reason for we spoke about an assault against the judiciary starting from 2017. I cannot speak in 15 minutes about all the provisions related to these changes, but I'm going to speak about two very important ones. One is about the creation of the so-called special section, SS. It's a section for investigating criminal offenses committed by judges and prosecutors. Is a prosecutorial office with no precedent in any country of the world. And of course, or probably you read a lot about the disadvantages of creating this new section. From my viewpoint, it's never a solution to try to solve a problem by creating a new institution. First of all, we should try to reform those who are already existing. but the legislator didn't do that, so created this special section, and the fight against corruption was somehow stopped, because in high corruption cases, most of the defendants tried to complain against a judge or a prosecutor, and this automatically moved the file from the National Anti-Corruption Directorate to this special section. It was functioning just with the 5 prosecutors out of 15, how the law was providing. So no results. Actually, everything which was reproached to the National Anti-Corruption Directorate, this special section did from the very beginning, because it solved very few cases. All of its indictments were finalized by acquittals in the court. They started to persecute, not just prosecute, some important members of the judiciary, including members of the present Judicial Council, prosecutors, and one of the judges. You know the case against the former general prosecutor of the National Anti-Corruption Directorate, who is now the prosecutor, the chief prosecutor of the European Prosecutor Office. So what this special section has done was an epic failure. And they also lacked some information in the press, the same thing that they reproached to the National Anti-Corruption Department. Still, the establishment of this section was sustained by a part of judges, because most of the prosecutors were against it. This is how we explained as these 5 members, because they have, there were very few applicants for this new position, and the majority of judges, because the General Assemblies of the courts and prosecutorial offices rejected the new laws. Still, we had some professional associations, some very famous judges who sustained this new created institution. Why was that? It's difficult but not impossible to explain, because, as I said before, unfortunately, who works a lot would make mistakes. And probably the National Anti-Corruption Department made some mistakes, because we can speak about acquittals in case of judges who were working in the High Court and now occupying some high positions in the judiciary, because after their acquittal they were reinstalled in their functions. We speak about a president, an actual president of Judges and Prosecutors Association. So it is difficult not to understand their position in sustaining some changes related to the prosecutorial process against judges. So it's sunny in Bucharest, you know. So we had 2 parts within the judiciary, one sustaining, a minority sustaining this new institution, and the majority opposing it. So the present is this. We had some troubles with the Judicial Inspectorate as well, but in this matter, the majority of us agree that there is room for improvement. So the apple of discord at this moment, and now I'm going to the 3rd part of my presentation, is this special section. And I think we should meet somewhere in the middle, because of course this section cannot cannot exist anymore. They did just mistakes since they were created, but it is not possible to turn back in time as we were in 2017, because we had these cases I was speaking about. So we have to meet somewhere in the middle and try to find some guarantees for those who need them. And there are a few solutions. We can speak about them if you want. I propose one of them. I think the solution is not to turn back in time. It is to have an additional guarantee. And the one I was proposing was an advisory opinion of the Judicial Council in case of the indictment of a prosecutor or of a judge. Some of our professional associations said that in such a way the council could block certain investigations, and I proposed a solution for these two, which would be an appeal on points of law before the panel of 5 judges of the High Court. But there could be solutions as well. To conclude, I think we had our great times from 1989 till 2017. We registered a lot of progress. In 2017, it was a backslide, and we started to ask if these progresses were or were not irreversible, as the European Commission asked itself in the cooperation and verification mechanism. I think we didn't stop that progress, and it was a good thing that within the Judicial Council, because even within the Council we had debates on this section and other provisions in the new law, but these debates within the Judiciary had their roles. Just as the dissenting opinion does, in a judgment. This role was to highlight the issues we should address, we should solve together, and highlight the weak points of these new laws. And speaking about the trust in the judiciary, I think it was increased by the way we reacted to this assault on our independence, because we reached out the general public, we explained the new provisions, we explained why they are a danger for our independence, we explained why the independence of the judge is important, because it is not for the judge, it is for those who come before the judge. So I think we did a good job after all, and our model is a model of success. If we want to look to the future, I think we shouldn't wait to address our weak points. We shouldn't wait to allow the other branches of powers. We should address them ourselves, and in this way we can prevent future actions trying to undermine our independence, to undermine the rule of law in our countries.
Thank you so much, Judge, just for that very interesting overview of some of the challenges that are facing the judiciary in Romania. And as you've said, there has been a lot of progress made, but more to do. And I'm sure we'll come back to some of those issues in the discussion part of today. So now I'm delighted to hand you over to Ramona Strugariu, MEP. You have the floor, Ramona. Thank you.
Thank you very much for the invitation. I must say that it is an honor to discuss about the judiciary and the justice system in Romania in such a company. I myself have an overview of the system, basically, and of the history of this progress that Romania made, but from the European perspective, let's say, with the different milestones and different let's say, recommendations that we had on this path, where we are, a bit of where we are today, looking at the 2004 pre-accession moment until the 2020 picture of the rule of law report. And I'm kindly asking you to bear with me throughout the process and I will try to move as fast as I can through these various points, but maybe it's important to mention those key moments because probably they're relevant for the later on discussion as well. So basically, we did have in December 2004 this political confirmation of the closure of negotiations for joining the EU, and there was this impetus for reform with the perspective of joining the European Union. And then we had this adoption of the Strategy and Action Plan 2005-2007 to reform the justice system. We did have the revision of the 3 laws package on the justice reform. And then also at the time, guarantees for the magistrates' personal and institutional independence, competitive examinations for management posts in courts and prosecutors' offices, accountability, and that was an important word at the time, accountability of general prosecutor and PNA prosecutor for the results of their institutions. Then, of course, drafting of new criminal and criminal procedure codes, and then in September 2005, the creation of the GNA structure, replacing basically the former PNA. The red flag on corruption was at the time the most serious situation that we were confronted with, so serious that it was deemed to bring a delay on our membership to the European Union. And that was fixed, I would say, through some rapid action from the Romanian judiciary with a lot of political pressure at the time. At that time, the political pressure was probably on quick achievements. And then in 2006, Romania was praised by the European Union for its progress, especially for the high-level corruption investigations, famous cases like Adriana Stase or George Copos. We had the first convictions of high-level politicians in our anti-corruption fight and history, I would say. Then we had this, the first CVM report that Romania ever had noted this need for irreversible and effective reforms, setting up, of course, sustainable structures and for investigating corruption, enforcing the measures in place at the time. And the 4 benchmarks with the judicial reform, integrity agency, which had significant progress at the time as well, tackling high-level corruption, and then, of course, fighting corruption within local government. And things went well for a while, but moving from one CVM report to the other, one could notice that the first backtracking came into our reporting since 2009. And there in the CVM report, we already, on the one hand, have received the praise of the European institutions and of the Commission for the anti-corruption fight. On the other hand, the signal that many of the investigations were blocked basically by the European Parliament, by the Romanian Parliament, and there were also attempts to restrict the rights of the prosecution. And this lack of political will was basically noted in the CVM reports in the upcoming years. Also with the mention that more was needed in terms of judiciary, accountability, and asset recovery. The key moment, the turning point, I would say, in this progress was probably 2012, 2013, the beginning of the Ponta governments, and also in 2013, more specifically, the due date for appointing the new prosecutor general and the new DNA chief prosecutor. And there, There was a highly political interference as perceived by the European institutions as well into this matter, resulting in basically a deal between the president at the time and the prime minister for the nomination of a prosecutor general close to the prime minister, at the same time keeping Laura Codruța-Kövesi at the head of the GNA. Strong criticism coming in the CVM report on this matter later on in 2014. Then also sensitivity was underlined in that report in relation to senior appointments of prosecutors, and the Commission pointed out the need for long-term political commitment. Then 2017 was the year of two CVM reports, as contradictory as basically sky and earth. The first one at the beginning of the year, noting some progress under the technical government and commitment from the government to change and improve things. The second one in November 2017, noting basically all of the backsliding generated after the first months of socialist governance. But then 2017 basically started with the emergency ordinance 13, and with all of the legislative changes following this emergency ordinance, the very strong reaction of the civil society and Romanian population overall in defending justice, taking to the streets to defend the justice system. Probably the letters signed by over 4,000 judges at the time, signaling the legislative changes and passing a very strong message for the protection of the judiciary, of the Romanian judiciary, became famous in Europe for sure, and probably they reached worldwide as well. In this context, basically, the reaction of the European institutions were extremely powerful as well, and also those institutions dedicated to the fight against corruption. We had the Greco reporting in 2018, and then the Venice Commission reporting later on in July 2018. Actually, 2018 was the year of two Greco reports, asking basically the Romanian authorities to re-examine all drafts concerning justice laws, especially appointment and dismissal procedures of magistrates, calling for maintaining the president in the procedure, discussing lack of transparency and rush procedures, serious concern over independence of prosecutors, and so on. You are probably aware also of the powerful reaction of the European Parliament with the resolution that we drafted in November 2018 on the rule of law in Romania, and then the most dramatic CVM report that Romania ever had in 2019. Mentioning briefly, because we started with 2004 and because I mentioned 2004 and those benchmarks at the beginning of my presentation, that we are in the situation of failure to comply with recommendations under benchmark 1, judicial independence and judicial reform, that efficient institutions such as DNA and ANI were weakened, losing certain competence, and particularly regarding the legal framework of ANI, we are also, and there are also serious concerns and risk backtracking on benchmark 2. And then we also, due to pressure on high-level courts, are at risk of not fulfilling benchmark 3 any longer. So we are 15 years later, according to the latest CVM, or the 2019 CVM report, back to square one. At least this is what one could see from a very, well, from the European reporting perspective, judging on how things evolved in the Romanian justice system. Well, there are a few maybe nuances here or comments that I would like to make before passing the floor to my colleague, because I'm not, I took already probably most of the time for my presentation. First of all, I must admit that I do not believe, looking also from the perspective of a member of the European Parliament now and what happens around us on the rule of law, I do not believe there is such thing as an irreversible reform in the justice system and in the judiciary overall. And this fight for having a balanced justice system and having a balanced judiciary and having the right checks and balances is a day-by-day fight. So I'm not sure how realistic was at the time the European Commission, very ambitious, it's true, but how realistic it was from the European Commission to ask for irreversible reforms. But we do need, for sure, as also underlined by all of the monitoring reports so far, the political will to change or improve a system, because in all of these years there was this huge question mark noted by the European institutions as well, whether the politicians, not the same politicians, but various, let's say, compositions of the parliament and government truly wanted a judiciary, a well-functioning judiciary. And I think this is not only a question for Romania, but it is overall a question for any political system in any of the member states which are confronted with let's say, periods of backsliding, of periods where democracy is at risk. Then a third and last remark would be that I would not go back to that point where we were in 2004, and since we do have the draft legislation on the table, having a possibility to reflect everything that happened in the judiciary in these years, maybe it is about time to look with a lot of honesty and a lot of ambition as well at the functionality of the judiciary, what do the voices in the system say about their needs, but also performance, but also space for improvement, about the resources that the system has in order to perform well today. And then, since we can almost 20 years later come up with a this fresh air and for the judiciary and for the justice system to do it by meeting somewhere in the middle. Because I like what Andrea said earlier, that yes, I fully agree, we need to meet somewhere in the middle. I don't think that any abrupt and historical perspective on what a justice system should look like is of help for any of the actors participating in this process, be it judiciary or governance or civil society as well, because luckily we're past those moments where handcuffing was a national pleasure and everybody was simply delighted to see rows and rows of politicians with their handcuffs in front of the DNA. It is important to have high-level prosecutors, but it is more important to enter a normality and a functional system where judges do their job, politicians do their job, and well, ideally, this is how a democratical and functioning rule of law system should look like. Thank you very much.
Thank you so much, Ramona, for that hugely interesting presentation and those insights. Now, finally, over to Laura Ștefan. You have the floor, Laura.
I will speak in Romanian, and I would start by saying that many of the points I wanted to touch have already been listed or emphasized by the previous speakers, and this is very helpful for me because I no longer need to go through the analysis of all events that happened in Romania, but I only need to build on what they've already mentioned. You note that when we speak of the Romanian justice, we spoke of anti-corruption. That's unavoidable. And then we wonder why this connection, this link always between these two very important, very sensitive areas in the Romanian public debate. And I would say we see an intrinsic connection, because when the implementation of an anti-corruption, high-level anti-corruption policy starts, we see the limitations of the system. And I'm not only talking about the judiciary, but also about the political system. And here is when the society undergoes an earthquake. And I think Romania is a very good example of what happens, what is very likely to happen in a society going through the transition between post-communism to a society based on the rule of law and separation of powers. And we see an earthquake in society. And this was completely predictable, because if we speak of high-level anti-corruption, those who have something to lose are very important people who have important resources, who have the mechanisms to influence public decision, and there are people who won't hesitate to use all these mechanisms they have available to defend themselves against what they perceive as probably being an unfair look upon them by the justice, because so far I have never heard someone to say, I am held accountable for what I did. I'm held accountable for because I made a mistake. I was holding a public position and probably I went further than the law allowed. They all have the same rhetoric. I'm being punished because I had someone upset. I'm being punished because the system doesn't want me. And here we get to the elephant in the room, and this has not been greatly discussed in Romania, but I do hope we are going to discuss this in the next years. And this is the actual independence of justice against other powers in the states, because justice does not simply exist there in a bubble. It is connected to other powers of the state, whether we speak of the political powers or about the connections with the intelligence services. And I believe it's not casual that in the report of the Venice Commission, when they analyzed what happened in Romania, which was quite shockful for Europe, the attempts to amend the criminal code and the criminal proceedings code, the attempts to amend the laws on justice, which turn into reality. So there an opinion suggesting a very serious analysis between the connections and interdependence between justice and law enforcement and intelligence services. Why is this important? Because, as you know, there is a saying, it's not enough to make justice. It is important to appear to make justice in an honest and impartial manner. So these polarized discussions in the Romanian society, because we are talking of a very hot topic, which is separating people into sides, makes people take sides. This has been quite strong, and in the past year we need to see good discussion about the valid viewpoints of all those around the table. Indeed, there was a very strong reaction from the Romanian society when they tried the decrimination of certain corruption acts. Actually, when they tried to wipe the anti-corruption results in the past years, we had very strong reactions and the highest level of protest in the streets after the revolution. And this showed that Romanians care. They care about justice and about the rule of law. Obviously, we won't see the nuance in the street. We cannot expect protesters to bring about subtle nuances of imperfections or system improvement. But I will give you a very recent example, running the risk of seeing even more agitation. Such street protests culminated on the 10th of August, when we all witnessed a very tough intervention by the gendarmerie against protesters in the street, people who were there to defend justice against political interference, and recently had a decision by Romanian courts to end this case, maintaining that there is no criminal act there. And the street reaction, I mean, you see the reaction, the split reaction and the reaction of the judiciary. So this, you can see there is no situation where we see general satisfaction and the illusion that we reached perfection in the Romanian society. And I believe that here it is important for the judiciary, as one of the three powers of the state, to get used to criticism, because criticism in the right amount does not kill, and it has to be informed criticisms. One of the problems in Romania is that the motivations, the justification of the court comes very late. Usually we haven't spoke about it, but we have cases where we have a person who gets convicted, goes to prison, gets out of the prison, and then, only then, you see the justification of the judge decision, of the court decision. And this is not normal. I know there is a work overload, but these matters should find an answer in terms of court management, judges' workloads, maybe employ more people to help drafting these documents. But this is unacceptable to receive the court judgment justification after having served your penalty. Now I would allocate a few minutes to the question, how come we survived? Because I believe Romania survived during these past years, and survived with minimum damage, because in my viewpoint, the key of these assaults against the judiciary was the amendment of the Criminal Code and the Criminal Proceedings Code, and these documents failed before the Constitutional Court. And I think this is where I find the answer to this survival, more specifically that you need to develop within your country sufficient antibodies so that you can resist the interference, so that you can resist the earthquake, not just to keep what you think is right, because some things will be lost in any negotiation. Some you lose some and you win some. But the question is, how can you maintain the mechanism so that you can move on and still function in an acceptable manner? Because we see this gap in the society, but also in the judiciary. We're talking about the voices in the judiciary which rather favored the setting up of a special section, because they said DNA had too much power and that's not healthy. Actually, we also have some comments in the chat on this topic. So we cannot avoid forever these discussions. We can avoid them for a while, but at some point you need to turn your attention there. And I would say there are a few topics which need serious discussion. One of them is the responsibility and accountability of the judiciary for their actions. And whenever you say accountability or responsibility, someone will say, this is a breach of my independence. And indeed, I don't think we have a simple solution. You know, we are people and we like simple solutions, but when problems are complex, then the answer might be just as complex. A simple solution about how you set up an accountability system which should not limit the functional independence of judges. You see, there are lots of discussions about this special section, about the judiciary inspection as accountability, as imperfect accountability mechanisms, as mechanisms which probably can be improved. Mrs. Chiș was also saying earlier, it's obvious we cannot stay as we are today, but it's obvious we cannot get back to where we were before. So obviously there is a need for dialogue and for a compromise which can be accepted by everybody. I looked at the opinion of the general advocate, and the opinion said there are no sufficient independence safeguards for this section, special sections. If I look at the results, well, it's obvious they were not, they do not provide too much safeguards, but what can we do? If I look at the law, I'm thinking, what can we do to guarantee the independence of this section? So, as I always say, people are very important, because the law might be just great, but if it is implemented or enforced for personal interests, then it will be with bad results. The actual independence of the judiciary, we already tackled this. We also need at some point to discuss the efficiency of the judiciary, because we speak very much about DNA. Recently, we started talking about the court as well. As you know, Romania holds a shameful position in Europe in terms of human trafficking, and it's difficult to get there without some help from the state, because we are talking about people being trafficked. We need to talk about success, but also about failure, and we need to see what we can do for the prosecutor's offices to be to have high performance everywhere, not only in just a few places which are discussed, and we then forget about everything else. And another thing which I find very important is the prompt drafting of court decisions, justifications. It's difficult to accept in a European country that it may take months, even years, for a person to receive the justification of a court decision. So the good news is Romania survived with noise, with tensions, with fights, but I believe that scandal is good, actually. I think an indicator of disaster is when you stop hearing anything from a country, and the fact that we yell at one another. It doesn't mean that some are always right and others are always wrong. I think the truth is different. I think there are bits and pieces of truth and justice everywhere, and we should try to build the puzzle and sit down and choose the topics we actually can debate, because it is just possible that we are not prepared to discuss some of them and reach the relevant point for the Romanian society. Mrs. Strugariu, and I will end here, she was talking about the benchmarks and CVM and what it brings to Romania. I will only give you one example where they speak about the predictability of court decisions. We made a test. We went to courts across the country. The object of the case was a request for public information. And we have, in the first instance, we have 50-50 solutions. 21 courts believe like us, and 20 courts believe different, and one of them gave us a first hearing, or scheduled the first hearing 9 months after we filed our application, and it's just the same in different matters with the it's just the same with the courts of appeal. So well, we are talking about a very old law. It's been enforced for 20 years. So if at this level we have such differences in the judiciary, in the judicial practice, then what happens in very complex matters? This is just an example, because I believe that at some point we should start a discussion about this and stop hiding behind general excuses like there is no case file is like the other. Yes, they are. We have, unfortunately, the courts overloaded with identical cases, repetitive cases, and I think we should tackle this in the future. So Romania survived. Romania is trying to get her act together and build a better system maybe than the yesterday's system, and maybe the conflict and the scandals are good. Thank you.
Thank you so much for that, Laura. So that's the end of part one. So for those who could only join us for the first part, thank you so much. Now we're going to move on to part two. So the way we're going to deal with this is as follows. I've noticed in the chat that there has been a lot of activity and some of the panelists are replying back, and that's great. Now, and my colleague, Marek, he's got one or two questions that he's also going to put to the panel. But I understand, Ramona, you may be in time difficulty. So I wanted to give you an opportunity now, if you wanted to touch upon any of the points that some of the other speakers made, or if there's any other item that you wish to address.
Yes, thank you very much. I unfortunately need to run in a few minutes, but I did look in the chat at the various comments regarding this, the opportunity of the special section, regarding the interference of intelligence services in the system, regarding a lot of the things that were mentioned here. And I fully agree with Laura that we also have to look at that, speaking about the role that the intelligence should have in a state, and the civil mechanisms that we can activate in order to balance this kind of power, because it is dangerous. And yes, we didn't speak enough about it. But I think that we were so busy putting up fires, at least for a number of years, and we were also in a very complicated political context, that we did not find a moment of opportunity and of quieter times where we can sit down and discuss about all of these things, which again do not only happen in Romania, or do not only happen to Romania. Look at our neighbors in Bulgaria, which also were doing progress, which had a great CVM report about a year ago, and are now taking to the streets and in a situation of serious political capture of all of the justice, or almost all of the justice and anti-corruption institutions. And the signals coming from there are very, very complicated ones. And I would say that, you know, things have reversed in less than a year, looking at the situation in Romania and the situation in Bulgaria. So we are not in a desperate context or in a desperate situation, but I think we are in a moment talking about the political shift as well, talking about for the first time in a long number of years, the political majority in the parliament, a more balanced one, I would say. Let's say that the way that the political will looks today is in favor of such a discussion. But then also looking at those things that we did not have the courage to talk about until today, such a debate is necessary. I don't think that politicians should continue to use populism as a tool when it comes to such serious things as the anti-corruption fight, or the way that the functioning system should look like, or how we should continue to praise a lot of results, or people, or turning people into gods, without criticism and without also looking at the less functioning parts of the system, because we are hurting the system. And because there's no thing, that's something that I keep saying about the way we look like as a society in the end. There's no such thing as gods in the justice system, gods in the political system, or gods in the economy or the society overall who will save us overnight. There is no such thing. A state, a functional state, is a state which is actually working, even if these gods disappear tomorrow. And of course, people are important in leading institutions. Yes, they are very important, and we have seen it as well. But apart from that, a functional system comes from the understanding of proper functioning of the legislator, of the law enforcement system, and of the citizens themselves. And that's how we should probably talk about the changes in the justice system as well for the next years. Thank you again, with apologies that I need to run. It was a pleasure to be part of the discussion, and I'm happy maybe to answer in writing questions that may come afterwards. Thank you so much.
Thank you so much, Ramona. We really appreciate your time today. So I'm just going to call on my colleague, Marek, who may have had a chance to look at some of the questions that we've had in the Q&A feature.
There was a lot of questions both in the chat and in the Q&A section, and some of them in Romanian. But the question seems to be in the idea of concrete debates, whether she can ask the opinion of the three panelists regarding the registration of the DNA prosecutors, from which it seemed to result that they were plotting to intimidate the judiciary.
I don't really think that we can speak about individual cases. We should speak generally about what happened in case of the National Anti-Corruption Directorate and what happened in the case of this section for investigating judges and prosecutors. A lot of reproaches related to the DNA, and I noticed that my colleagues who supported the legislation introduced after 2017 are present, and try to explain why this section, I respect that. It was embraced by a small minority of judges, rejected by most of them, and the vast majority of the prosecutorial offices that time. And as I don't remember very well, Ramona or Laura already said, almost 4,000 judges and prosecutors undersigned an open letter against the draft law which proposed the creation of this institution. The Judicial Council itself gave a negative opinion on it when it was proposed by the executive. After that, the executive gave up, so went further with this proposal, but the parliament created a special commission and for debating the new laws, and the colleagues in the chat were invited and supported. They had these arguments. They wrote down in the comments, and I answered them. Of course, we can debate this many hours. We did that in Romania. But I think the general opinion within the judiciary is that this apple of this court has to go, because it has no results. It doesn't solve the corruption within the judiciary. It doesn't solve the corruption cases brought before this prosecutorial office because a complaint was filed against the judge in a high corruption cases. And all of their cases finalized with indictments in the courts received acquittals. If the DNA would have such results, I cannot imagine their reaction. I'm not saying that there were not acquittals. Some of the colleagues in the chat unfortunately experienced this, and I understand them, and I regret that, and I think that it is important to address that issue, but the solution is definitely not solve something which is creating something even worse, because this section is the worst thing we can imagine, because it is against any judge or prosecutor in Romania investigating any crime, not just offenses related to our duties in the office, but any offenses, any criminal offenses. And and this with the Judicial Inspectorate, who was subordinated to just one person who adopted the regulation of this inspectorate, one person who organized the competitions for the inspectors. I think these two very important tools, the criminal liability and the disciplinary liability, can weaken and weakened actually in reality the independence of the judiciary. I know that my colleague said that the chief prosecutor, the deputy chief prosecutor, the prosecutors in this section were appointed by the plenum of the council. But if you will check, you will see that actually those persons were supported by the executive as well, because, for instance, the first chief prosecutor was the former deputy chief inspector, whose mandate was prolonged by an emergency ordinance contested before the the Court of Justice. So this person, preferred by the executive, was appointed by the Judicial Council. It's a long story to explain the procedure. The second chief prosecutor was another one who was nominated by the former Minister of Justice, who revoked Laura Codruța Kövesi from his office. So he proposed another prosecutor as her successor, and that prosecutor was rejected by the president of the state, and the council tried to appoint that person as a chief prosecutor. It was a strong opposition. I was part of that opposition, and eventually she gave up this attempt to become this chief prosecutor. The first chief prosecutor now is a member of the Constitutional Court, nominated by the Chamber of Deputies in the former parliament. So you can see that those who were preferred by the executive and the legislator were nominated or appointed in high positions in this new section. So just saying that the examination commission is compounded mostly by judges is not enough to assure the independence of this new organism, because if you look at those people specifically, you will see that they are related to the executive and the legislator in the way I explained you.
If I may also make a point on this one, I think if we extrapolate this, you see that there's no magic formula to judicial independence, because on paper, the section is selected and appointed in the most independent way possible. And some of our viewers argue that they also behave independently. Yet you see these links with political parties and political people that then forward you in your career. So again, I think we have a very difficult task before us to understand that as good as they may look on paper, procedures are just as good as the people implementing them. And also to understand that even judicial councils are not a general solution, are not a panacea for all our problems. And that, the views in the society are equally reflected inside the institutions, and in this case, inside the Superior Council of Magistracy, inside the judiciary, as you can see from the lively debate on the chat. So, and people care deeply about these things because they truly believe that their position is the right one. Yeah, whether they're for or against this special section. Now, I personally am unable to see how the creators of this section imagine that it can ever perform efficiently its function, just because they put all the crimes committed by judges and prosecutors there. So how can you possibly think that a handful of people in Bucharest could investigate all the allegations against judges and prosecutors throughout the country? We know that judges and prosecutors are particularly targeted individuals in all these complaints, and that 90% of them or even more are superfluous, and they are motivated by other reasons than criminal grounds. So yeah, I think this is a discussion to be held. And on safeguards, we've seen a lot of acquittals. When cases were weak, we had acquittals from judges. That for me is an indicator of strength of the judiciary, meaning that they don't take all the cases that come to them and they simply act as a notary public stamping them and agreeing with the prosecutors. We've seen a lot of acquittals, not only for the special section, but also in DNA cases, also in DCOT cases. And you know, it's easy at the societal level to say, yeah, it's always the judge's fault. But I think we are beyond that already. And I think people are starting to understand that it's not always the judge's fault. And if you truly believe in judicial independence, you should accept it also when you don't like the solution. Yeah. So maybe there was not much to the case, to be honest. Maybe the crime that was investigated was not found to be a crime in the end. So there are many reasons why you could get an acquittal, and I think because of the lively debates on these topics in recent years, Romanians have become doctors of law, at least in their minds, all thinking that they can understand these things. But definitely the idea that it's sometimes it may not be the judge. It may actually be that the judge is doing his job correctly, you know. Yeah, and then we get to the question of accountability and responsibility, which is a tough one. So yes, in general, if you're not guilty and you got an acquittal, everything is fine, except for you, because your life has been impacted in a big way, yeah? Maybe you lost your job, maybe you lost your health, maybe you lost your family and friends. So at what point should we bring into question the idea of responsibility? And as I said, whenever we say that, the immediate response is that would impede on judicial independence. And yeah, here we are.
You know, reading the comments, I understand I don't know, the rage of some of my colleagues. And this was the reason for I said that we cannot stay or stick with our opinion saying we are right and the others are wrong. I said that in my presentation. I don't think that it is right to say that what was before was perfect, but it also isn't right to say what is now is perfect. So we have to meet somewhere in the middle and try to find other safeguards that those existing now or those existing before.
Absolutely. I was just going to come back to one issue, and as you say, Laura and Andrea, and we can see the comments as well in the chat. So thank you all very much, participants. I understand that it might be a little bit frustrating for you that you don't have a chance to speak in this particular format. It's clear that there are a lot of issues there, and I think all three panelists have said that it is good to talk, so it's clear that there's a lot more talking that needs to go on. But and there are a lot of complex issues too. But I just want to bring up one point, and that's the perception of the public towards the judiciary. So it's clear there are a lot of complex issues that are here, but I think in one of the latest reports from the EU, they noted that the level of public trust in the judiciary was decreasing, and perhaps they themselves had questions about judicial independence. So I just wanted to ask Laura and Judge Chiș, maybe quickly, if you might be able to address this, like what can the judiciary do in order to try and to change that perception within the public?
I think it is necessary to explain those solutions which are of great interest for the general. Mentioned the call 10th of August. So the Judicial Council has already taken measures at my request, because we asked the Judicial Inspectorate to investigate what happened in that file. And after we have the report of the Judicial Inspectorate, we will explain to the general public the solution. We cannot do that without having the motivation of the judgment. We are waiting for it. Another thing is to try to maybe to change the law and motivate our decisions before pronouncing them, especially prolonging the term for motivating our judgments, and maybe finding other solutions such as standardizing procedural acts, trying to limit the number of characters, because in the 21st century, we do not have time for drafting, reading very long procedural acts. In high corruption cases, we speak about judgments written on hundreds, maybe more than 1,000 pages. It is very difficult for a judge to deliver such a difficult and long judgment, even in 3 months, as the law allows him or her to do. So this is what we are going to do, to try to explain everything which is of interest for the general public, try to deliver our judgments in a short time, because justice delayed is justice denied, and try to reach out the general public in as many ways as we can.
Very good. And Laura, then from your perspective, NGO perspective.
The moment you start talking and you start testing the judiciary, you start seeing also things that you don't like to see. But that doesn't mean that those things were not there to begin with. It's just that now you have more transparency and more outspoken positions on key issues that pertain to the judiciary. So again, yes, it's the same with high-level corruption. The moment you start fighting it, people start understanding that this is a threat in their society, and the perception raises. It doesn't decrease, or it doesn't decrease immediately. The same with the judiciary. You talk about it, you start seeing flaws in the system. You're shocked at the beginning because you thought that here there was this ideal system that operated somehow perfectly in a country. Also, I think the debate is wider than that. There's a lot of discussion right now about the special pensions of various categories of people, one of which is judges and prosecutors. And, this is easily taken home by people because they see the large disparities in terms of retirement age and also the value of the retirement as such. So I think probably 80% of the decrease comes from actually people finding out how the justice system operates, with its flaws and its imperfections. And it's not pretty, but I think it's better than having this idealistic image about the justice system. So again, I see the glass half full. So I see the good part of the story, which means that people are more aware of the imperfections and will demand more of the justice system, not just of the politicians, but also of the justice system. Because let me conclude by saying that, you know, you hear a lot about the DNA is bad or the special section is bad, they have political connections and so on. Let me just bring to you the fact that they are all prosecutors, all magistrates. So if magistrates are so politically independent and impartial, how come we complain about these two groups that are basically composed of prosecutors? So again, maybe it's a wake-up call, and I hope that also a starting point for a more meaningful discussion.
Very good. And on that positive note, I've my eye on the clock. It's time for us to complete this session. I just want to thank you all. I want to thank our interpreters. I also want to thank all of our participants. Thank you for the comments that you made. Thank you for your participation. Also to the panelists, we really appreciate your time for this event and the time that you spent preparing. So Judge Andrea Chiș, to Ramona Strugariu, MEP, and to Laura Ștefan from Expert Forum. That was incredibly informative, I'm sure. And we hope that you will join us at the end of May and in June, where we'll have further sessions on spotlights on Hungary and Ukraine. And there will also be a recording of this session available on our website in 2 weeks. So stay well and stay healthy, everybody. And thanks again for your time.
Thank you.
Thank you.